Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
The period for filing of certificates of candidacy for the 2025 national and local elections has just ended, and we're once again seeing a deluge of candidates seeking public office. Some names new, some names old, and there are some you may consider with slim chances of winning. Are they necessarily nuisance candidates? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 11th of October 2024, and today we talk about who can be considered nuisance candidates in the context of a specific case. The case of Norman Cordero Marquez versus the Commission on Elections, decided on June 28, 2022. It's an unbanked decision penned by Supreme Court Associate Justice Ami Lazaro Javier. And joining us to talk about this case is Attorney Mac Vincent Niera from the Office of Associate Justice Lazaro Javier. Hi, Attorney Mac. Thanks for joining us. Welcome to the Supreme Court Podcast.
Good day, Attorney Mike. Thanks for having me.
All right. So, first off, Attorney Mac, do we know who this Norman Cordero Marquez is? What's his background?
Well, Mr. Marquez is an animal rights advocate and co-founder of an advocacy group, Baguio Animal Welfare. He travels across the country to participate in animal rescue projects and extend free legal assistance in animal cruelty cases. He filed a certificate of candidacy for senator in the 2022 national and local elections.
So this is a guy who has an advocacy for protecting animal welfare, and now he wants to transition to becoming a lawmaker. So if he has that advocacy, he wants to run, why was he declared a nuisance candidate by COMELEC?
According to the COMELEC, Mr. Marquez filed his COC to mock the election process. It alleged that he was virtually unknown to the entire country, that he was not officially nominated by any political party, which decreased his capacity to mount a rigorous campaign. And lastly, he does not have a nationwide network of supporters to assist him during the campaign. Thus, the COMELEC concluded that Mr. Marquez had no bona fide intention to run for office.
But is this the first time that he was declared a nuisance candidate?
Actually, Attorney Mike, this was the second time already. Prior to the 2019 national and local elections, the COMELEC declared Mr. Marquez a nuisance candidate for supposed lack of financial capacity to wage a nationwide campaign.
So, Attorney Mac, just to be clear, the grounds that the COMELEC cited for disqualifying him in 2019 were different from those in 2022.
According to the COMELEC, the grounds were different. In 2019, the ground alleged was lack of financial capacity to wage a nationwide campaign. And in 2022, it was the lack of a bona fide intention to run for public office.
So what happened to that disqualification case in 2019? Was he ultimately disqualified?
Marquez also went before the Supreme Court in 2019 to assail his disqualification. The court ruled in his favor, finding that the COMELEC cannot impose a property qualification on persons vying for public office.
So is the Supreme Court saying that the COMELEC cannot discriminate on the basis of the wealth of the person running?
That's precisely it, Attorney Mike, because the 1987 Constitution only imposes age, citizenship, literacy, voting, and residence qualifications on senatorial candidates.
So if Mr. Marquez has been declared not a nuisance candidate by the Supreme Court for the 2019 senatorial elections, why did the COMELEC declare him again a nuisance candidate for the 2022 elections when, of course he can say, the Supreme Court has said, I am not a nuisance candidate.
Taking its cue from the 2019 ruling, the COMELEC still disqualified Marquez. Instead of pointing out his supposed financial incapacity, the COMELEC alleged that he had no bona fide intention to run for public office. However, when you look at their allegations, as the court did, they were indirectly pointing again to his lack of financial capacity.
So when this case came before the Supreme Court, did the Supreme Court decide to rule on Marquez's petition on the merits? Wasn't it moot?
The petition of Marquez became moot with the conclusion of the 2022 national and local elections. Still, the court saw fit to rule on the merits because Mr. Marquez's case was capable of repetition yet evading review.
Attorney Mac, that phrase, capable of repetition but evading review, what does that exactly mean?
This is an exception to the mootness doctrine. Without any guidance from the court, the COMELEC would be able to utilize the grounds it used against Marquez in subsequent elections, not only against Marquez, but also against other candidates.
So in short, the Supreme Court is saying technically this is moot because the elections are over, but because in the future this might arise, so we're deciding to settle this issue. So that's why they decided to rule. So how did the Supreme Court rule on this issue? Was he a nuisance candidate?
In this case, the court found once again that Mr. Marquez is not a nuisance candidate. Although the COMELEC cited apparently different grounds to declare Mr. Marquez a nuisance candidate, such that he had no bona fide intention to run for public office, upon closer inspection, these allegations by the COMELEC are heavily intertwined with the grounds previously used against him in 2019. For instance, the COMELEC alleged that he is unable to persuade a sufficient portion of the electorate to support his candidacy. Also, they claimed his non-membership in a political party against him. And lastly, the COMELEC alleged that he lacks the ability to make himself known to the entire country and the electorate. So what's common with the three reasons that the COMELEC raised against Mr. Marquez? So what's common among the three things that the COMELEC raised against Mr. Marquez? They all relate to his capacity to wage a campaign. And I ask you, what is needed for an election campaign? Of course, the expenditure of time, resources, and funds. So it all boils down to having money or the resources to run. And the Supreme Court said you cannot impose that. Yes.
Right.
So the COMELEC just used different words for the same ground. And it is a basic doctrine in our legal system that what you cannot do directly, you also cannot do indirectly. And in this case, the court had to point out what the COMELEC was doing.
Mm-hmm. But what about the allegation that he has no intention to run?
Actually, Attorney Mike, the court found independently that Mr. Marquez had a bona fide intention to run. The fact that he questioned his disqualification before the Supreme Court twice is telling, because no reasonable minded person would go through such a lengthy judicial process if he or she actually has no bona fide intention to run. So, just to simplify, Attorney Mac, which factors shouldn't be used to declare an individual a nuisance candidate? First and foremost, being virtually unknown to the entire country except the locality where the candidate resides, because this reduces the election to a popularity contest.
Mm-hmm.
Next, non-membership in a political party or lack of political connections or affiliations. Third, failure to prove financial capacity. And lastly, perceived inability to mount a successful election campaign.
Mm-hmm. So, you've mentioned what shouldn't be used, but what factors are indicative of being a nuisance candidate?
A factor would be when a candidacy is clearly being used to mock the electoral process. For example, fielding candidates bearing similar names to other candidates to cause confusion on the ballot. But insofar as lack of bona fide intention to run for public office is concerned, there is no hard and fast rule. So, who has the burden of proof, of proving that these candidates are nuisance candidates? Because, thousands have been filing their COCs. So how do we know out of the thousands filing their certificates of candidacy that they really have the intention to run for public office? Actually, that's a very good question, Attorney Mike. Because in this case, the COMELEC only made allegations against Mr. Marquez. It did not provide any evidence as to its claims. So in this case, it was the COMELEC Law Department who alleged that Mr. Marquez is a nuisance candidate. So therefore, it is the COMELEC that has the burden of proof. But what about those who are filing a complaint or questioning the candidacy of another candidate? Well, the one who alleges something must prove their claim. Mm-hmm. But let's talk about the logic of all of this, Attorney Mac. Why is there a need to exclude candidates and declare them as nuisance candidates? Can we not just say, let's allow the people to decide? After all, this is a democracy. Who's to say that one is nuisance or not? So what's the logic? Why should the COMELEC keep on excluding people as nuisance candidates? From a practical point of view, if we don't adopt a mechanism to exclude nuisance candidates, there just wouldn't be enough space on our ballots, as the COMELEC claimed in their submissions. Is simply saying in this case is that the COMELEC must clearly prove that a candidate is a nuisance before they can be excluded from the ballot. All right, thank you so much, Attorney Mac, for this very enlightening discussion. Thank you as well, Attorney Mike, for having me so that we can shed more light on this very important issue. All right. And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library
Just search for Norman Cordero Marquez versus Commission on Elections, GR number 258435. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
At the Supreme Court this week. The Supreme Court emphasized that simply violating ordinances and regulations is not enough to justify a warrantless search and seizure, especially when the penalty does not involve imprisonment. The court acquitted a man of illegal possession of a firearm after finding the seized revolver inadmissible because it was the result of an illegal search and seizure. The accused was arrested by the police for entering a one-way street. A traffic violation, however, does not call for an arrest, but merely the confiscation of the driver's license. As there was no valid arrest, the warrantless search that followed was also not valid. In another case, the Supreme Court declared unlawful the registration of the Gloria Maris trademark under one of the company's incorporators. The court ordered the cancellation of the certificates of registration over the Gloria Maris trademark, consisting of the words Gloria Maris with a shark's fin enclosed in a plate of an irregular shape in the name of Pacifico Q. Lim. The court ruled that a trademark registered in bad faith, as in Lim's case, may be cancelled for being unfair competition under the Intellectual Property Code. The Supreme Court welcomed two new justices appointed to the Sandigan Bayan on October 8, 2024. These are Associate Justices Hener Malaluan Gito and J. Ermin Ernest Louis Ramirez Miguel. Executive Secretary Lucas P. Bersamin transmitted their appointment papers to the Office of the Chief Justice on October 9, 2024. On the same day, the Supreme Court en banc held a preliminary conference on the petitions in Pimentel et al. Versus House of Representatives et al. And Colmenares et al. Versus President Marcos et al. The first petition challenges Section 1, Paragraph D of Provision 43 of the General Appropriations Act 2024 and Department of Finance Circular 003-2023, which allows the return to the National Treasury of GOCC excess reserve funds to fund unprogrammed appropriations. The second petition, on the other hand, seeks to nullify the Presidential Certification of Urgency for House Bill No. 8980 or the General Appropriations Bill, absent the existence of any calamity or emergency under Article 6, Section 26, Paragraph 2 of the Constitution. Finally, the Supreme Court continued to seek input, suggestions, and feedback from judges and court employees from first and second level courts in Bacolod and nearby provinces at the regional consultations for the proposed amendments to the Rules of Criminal Procedure on October 9 and the proposed amendments to the Rules of Civil Procedure on October 10. The regional consultations aim to engage various stakeholders, including judges, legal practitioners, and the academe, in discussing proposed amendments to the Rules of Civil and Criminal Procedure. And that's your Supreme Court this week. I am Tiffany Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, and YouTube. You can also catch previous editions on our website. And for the very first time, you can now hear this podcast on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Irania as researcher, Don Ryan Balza and Victor Laranio as sound editors, and Tyke Flores as web editor.